This is the RM of Springfield meeting agenda for May the 20th, 2025 at exactly 6 p.m. I'm going to call the meeting to order. Land acknowledgement be read by myself, Mayor Patrick Therrien. The RM of Springfield acknowledges that we are gathered on ancestral lands, Treaty 1 territory, traditional territory of Anishinaabe, Cree, Oji-Cree, Dakota, Dene people, and on the national homeland of the Manitoba Métis, of the Red River Métis, sorry. We'll go to item number 4, and that's the approval of the agenda. Can I get a mover and a seconder for that, please? Glenn and Melinda. Any additions, modifications, or?
Your mic on there.
Yeah, no, it's on. Oh, maybe here. How's that? Better? And I will. Okay. All right, approval agenda. I've got Glenn and Melinda. Any additions, modifications, deletions from council? I see none. Can I get a show of hands of those in support? Unanimous and is carried. Then we can go to delegations. That's 5 or 5.1. And we're a little bit ahead, but Edwin's not here. Maybe if we can start with Daniel, would you be ready to go? Okay. Maybe we'll just wait a second. Maybe he's in the foyer. Yeah, we've got 10 minutes there. We'll just wait until Christy gets back. If people are online, we're just waiting for one of our delegations to attend. We may just go back to a little bit of rearranging here until we figure out next minute or so where our delegation might be. We may just go to bylaws. Do we need Krista here for bylaws? Okay. If council's good, if we can do maybe no, nothing. If we can maybe Daniel, maybe what we'll do is we'll wait till 6:10 if that's okay, and then we'll go from there. If we can go to bylaws there, if everybody's in agreement there, while we're waiting for Mr. Giesbrecht. 7.1, mover and a seconder for bylaw 2505, use of firearms, second reading. Mover and a seconder, please. Patrick or Melinda and Andy.
Be it resolved that second reading be given to bylaw number 2505, being a bylaw to regulate the use of firearms in the RM of Springfield.
Any comments, questions from council with regards to second reading? I see none. If we can do a show of hands in support of the question bylaw as it was read. That is unanimous and is carried. That was 7.1. If we can go to 7.2, that'll be the third reading of 2505. Get a mover and a seconder for that too, please. Melinda and Andy.
Be it resolved that third and final reading be given to bylaw number 2505, being a bylaw to regulate the use of firearms in the RM of Springfield.
With the resolution being read, can I get a show of hands of those in support? That is unanimous and it is carried. If we can go to bylaw 2507, taxation bylaw, first reading, 7.3 on the agenda. Mover and a seconder, please. Melinda and Patrick.
Be it resolved that first reading be given to bylaw number 2507, being a bylaw of the RM of Springfield to establish rates of taxation and impose taxes for 2025.
Any questions from council? I see none. I'm going to get a show of hands of those in support of 2507 taxation bylaw first reading. That is Councillor Warren, Fuel, and Therrien. Those opposed? Councillors Miller and Kaczynski. So passed. If we can go to 7.4, please. That's bylaw 2508. That's utility rates, first reading. Mover and a seconder, please. Glenn and Melinda.
Be it resolved that first reading be given to bylaw number 2508, being a bylaw of the RM of Springfield to establish water and wastewater rates for the Springfield utility.
Questions or comments from council with regards to the first reading? Councillor Miller.
Thank you, Mayor. In terms of 7.3, or I should say 7.4 bylaw 25-08 utility rates, these reflect, it might be more of a question for administration, but these are rates reflecting the new utility, the DAOs at all?
Yes, so there is approximately $3 million of the DAO's project that is being recovered through the water and wastewater utility rates.
So that 3 million will be recovered in what period of time?
That is over a 20-year period, I believe. We have that spread out.
Okay. And what would be the anticipated percent increase for individuals from what the rates are now to what they're going to be?
I have to pull up the executive summary here.
And that would be primarily, obviously, just on people who have water service, right?
Correct.
Currently.
Including the debt surcharge. I don't think it's broken out just with the debt surcharge, but it basically goes from 2026 proposed increase of 9.4%, and with the debt increase, it jumps to 29.5%.
29.5% year over year, right?
That's the first year. And then if you look at 2027, there's an increase of 8.6% with no debt surcharge, and it actually drops to 7.3% with the debt surcharge. And again, it drops to 6.9% in 2028.
Great, thank you.
Okay.
Any other questions, council? I see none. If I can get a show of hands of those in support of the first reading, 7.4 on agenda, bylaw 2505 utility rates. So those in support? That'll be Councillor Warren, Fuel, and Therrien. Are those opposed? Be Councillors Miller and Kaczynski, and so passed. Then now we'll get to delegations there. I see Mr. Giesbrecht is here. Edwin, if you're ready, you can use the new podium thing there. Oh, you're welcome. Want a glass of water or anything, Edwin?
Oh, some raspberry ginger ale.
Hey, great brand.
I haven't tried that yet, but it tastes pretty good.
All right, Edwin, it's 15 minutes when you start with your
15,
name.
sir? I thought it was 10.
Oh, I'm sorry, 10 minutes.
Yeah. Well, no, it's fair is fair, and I play by the rules. So, Christy, if you could bring up the first slide. First of all, my name's Edwin Giesbrecht, a longstanding resident of Springfield, and I'd like to thank council here for allowing me as a delegate. And as to the first slide on your screen, what I would like to say is to our house, our democracy. Before we begin, I want to acknowledge what this place is supposed to represent. This is our house. not theirs, ours, all together. And the strength of a democracy is measured not by how those in power speak, but by how they answer. What you're about to hear isn't anger, it's accountability. Second slide. Sworn pit theft briefing note. Let's talk about what the public wasn't told. This wasn't just an operational detail. It was called a briefing note. But the title chosen uses the word removal, not theft. That word choice matters. It changes everything, and it sets the tone for what followed. Next slide, please. Theft alleged, RCMP blocked. Around 2018, residents took concerns of gravel theft directly to the RCMP. An officer visited the RM office, but was told the matter was being looked into by a lawyer. And that was the end of it. Yet in 2020, the RM filed a civil claim confirming they knew it was theft all along. So why was the RCMP told to back off in the first place? This wasn't delay, it was deflection. We may not know who gave that response, but we do know the same senior administration remains in place today. Slide 4, please. Criminal path suppressed. After being sworn in, the mayor, a 37-year RCMP veteran, was asked by a former councillor and petition signer what he intended to do about the theft. His response, too much time has lapsed. The question now belongs to the public. Was that leadership or avoidance? Slide 5, please. Civil delay and settlement concealment. They waited 2 full years before even filing a claim, then dragged it out for nearly 5 more. All the while, the evidence sat in plain sight. No councillor attended the final resolution hearing, even when asked by a resident. The public should now ask, was this delay a tactic to avoid exposure? Was the civil settlement used to silence scrutiny and protect someone inside governance, past or present? And if the defendant relied on a gag clause to walk away, does that look like justice or a deal made in the dark? Next slide, please. Legal authority lacking. No council vote, no resolution, no record of direction. This municipality is an incorporated body. It cannot delegate full settlement authority to an individual behind closed doors. So who authorized the signature and under what legal right? If that answer doesn't exist in the minutes, then this settlement may not exist in law. The people have to ask, was this an honest mistake or an abuse of authority disguised as process? Next slide, please. Legal fees and turnover. 3 different law firms handled this file. That alone should raise eyebrows. How much did this turnover cost the public? Where are the invoices? Legal fees may be buried in general accounts, but that doesn't mean they're invisible. The people deserve clarity, because if this were your household budget, and it is, you'd want to know, what exactly did we pay for and who kept the meter running? Next slide. Violations of the Municipal Act. Section 83, subsection 1 requires council to act by resolution. Section 252, subsection 1 governs financial decisions. Neither appears to have been followed here. A settlement signed without a recorded council vote is not just poor governance, it may be unlawful. This isn't a paperwork issue. It's the line between authorized municipality action and unsanctioned discretion. The public must decide, if this wasn't a breach, then where is the line? Next slide, please. Financial loss, $2.2 million to $260,000. Financial loss and survey swap. The RM once estimated over $2.2 million in missing aggregate. That number wasn't casual. It was sworn in a statement of claim, signed as verily true. Yet the settlement came in at just $260,000-ish. Apparently, following an appeasing survey controlled by the defendant who held that data and knowledge since around 2021. There's no record of an independent review, no explanation for the gap. And if the original number was false, then who signed it under oath? If it was true, then who gave it away? The people must ask, was this an honest correction or a legal contradiction with consequences? Next slide. Ignored petition and dossier. A 98-page dossier, a repatriated petition signed by over 120 residents, submitted, delivered, but still no formal response. Council was informed that only an independent RCMP investigation could properly estimate the scale of loss. Yet the public record shows no motion, no referral. Were some members of council not kept fully informed? That's possible. But if this was seen and still ignored, then the public must ask why. The people did their part. Did council do theirs? Next slide, please. Council's duty and exposure. Council does not and cannot legally condone theft. To aid and abet by endorsing what it once accused in court demands scrutiny. You cannot name theft in a lawsuit, then turn away when the criminal path is raised. A civil settlement does not erase a sworn criminal allegation. To remain silent in the face of wrongdoing is not neutrality, it is complicity. The public must ask, when council had the chance to act, did they uphold their duty or shield the follow? Next slide, please. The smell lingers on. If what happened here had been exposed sooner, would we still be standing in the same place? If the system failed to protect the innocent, then who protected the system? If the canary didn't make it, what kind of air are we breathing now? And who exactly will answer for it? Next slide. Buried, not resolved. The public deserves answers. Who authorized the settlement sign-off? Where are the legal invoices and the full gross legal costs? What communications were withheld from council or the public? If council refuses to refer this matter for investigation, the public is left to ask why? Because others already have. The Ombudsman and the RCMP now hold parts of the record. It's time to complete the briefing. Call your councillor, call the Ombudsman's office, call the RCMP. It's your right, it's our money. This was buried, not resolved, and the truth has a way of surfacing. Next slide, last slide. The numbers don't lie unless you let them. These numbers tell a story and not the one they had hoped to bury. From millions lost to trust broken, this one wasn't just a failure process. It was a failure of duty. The facts don't flinch. They fudged what was taken, concealed who signed what, and buried the rest. The truth didn't change, only who had the courage to face it. These numbers won't disappear, and neither will the people watching. This matter will be referred again to the RCMP, and we can only hope that this council administration will finally find the courage to involve the proper authority. I thank you, Mr. Mayor, and I rest.
I thank you, Mr. Giesbrecht. Are there any questions from council? Councillor Miller?
Thank you, Mayor, and thank you, Mr. Giesbrecht, for your explanation.
Delegation this evening. I have a couple of questions. First, a couple of comments. As you know, when this originated, I wasn't on council. That's not to shrug the responsibility. dealing with this.
There. Okay, as you know, this came to light somewhere around 2019, prior to myself being on council, actually most of us being on council, so I'm not trying to shrug that responsibility because it's before us now. But I wanted to tell you that when that court proceeding was happening, I wanted to make every effort to attend, and I know others did too. I was away out of the country, but that's not an excuse. I believe we were advised that it wouldn't be advisable to attend that particular session, and so I think you hold a little different point of view that all court matters are open to the public, and for the most part they are. However, I'll let you respond to that.
Do you want my response now?
Sure.
Not necessarily are all court hearings public, and especially the Queen's and King's Bench have deviated away in family court, especially. The certain circumstances in this particular case of the rural municipality of Springfield versus Chabot aggregate, that was actually a assisted court judge, a separate judge from the trial judge, being assigned for a dispute resolution. And so this was a last minute Hail Mary. And under that dispute resolution, that would be then privileged to the entities directly involved within the suit, which would be the rural municipality of Springfield and Chabot, and not the general public. However, because we are an incorporated body, the council actually holds like a board of directors on a corporation, an organization of business. They hold the final decision. They may appoint somebody for intermediate as a single go-to up to the points of getting into the serious business at hand. And then generally a board member wants to be there, or a counselor, of which you may have been advised it might not have been to your best interest. That may be possible. That may or may not have been an ill advisement. However, because we are an incorporated municipality, a very senior manager with the Law Society of Manitoba concurred with me within 2 minutes that in fact it would have been any councillor's right to attend that meeting, period, bar none, because you are the client. It is council who is the client. The CAO or administration is not the client. It is the council of the rural municipality of Springfield, the elected officials, who are the actual client. And that was concurred by the Law Society itself. So that's why I can understand first-term councillors and even incumbent maybe not being that familiar with that genre of that type of court intricacies. And so if in fact they maybe had some sort of interpretation of something that set fear into you for some reason to attend that, that was a false fear. It was a false flag. And again, Law Society absolutely 100% concurred.
Thank you for that answer. I have a couple other comments or questions, perhaps. You indicated that, yeah, there was a settlement reached. That I kind of understand, but we've also, as an administration or council, directed administration to put together a briefing note, and I believe that that's available. And is it posted now online about the situation? Like there was that one pager, or maybe it was two, but is that something that Mr. Giesbrecht could have? I mean, not only Mr. Giesbrecht, but residents could have access to, because that might clarify some particular issues here.
Yeah, that was posted on the agenda. At the same time, it was read out in the public, and I believe it was also posted on our website, but I can confirm that it's still up there. But yeah, it's available on the council agenda.
So, Mr. Giesbrecht, have you seen that briefing or debrief?
Yeah, I did see the brief. I concur with Madam CAO Draper. It is there, it's on the website, but it is a brief. Well, having said that, it's not the settlement. And in fact, I have currently some 42 days running a FIPA request for the actual settlement for the wording so that I can read the actual settlement document. And I went so far as to even disclose, because there was a discontinuance signed by the Chabot representation, which means they're not pursuing anything either. It eliminates, in my mind, the possibility of what's called a term sheet, or a sheet that's put into a settlement sometimes where there's a term where an individual or one of the representations of either the defendant or the complainant can change their mind on the settlement. And because of the discontinuance that was filed by Chabot in the King's Bench, which was the final document recorded, I don't think there's any timesheet. So that's why I am requesting the actual settlement and not a brief. I've done many briefs, and briefs don't necessarily tell the whole story.
Okay, so something was left out of that brief perhaps. So you want to know particularly what legal fees did we incur, which is public, but as you say, it's in the mishmash of financial
Not in the brief.
No, not in the brief, but perhaps we could find that information out to you. And again, it's already been displayed on the financial plans as we go over the years, right? So it's hard for you as Joe Public to pull all those legal fees together. In other words, what I'm trying to say is, can our administration come up what it cost us over those many years to do this court challenge? And second of all, who authorized the settlement itself? So I'm a strong advocate for transparency and accountability. The question from the public would be who, as you say, and you've asked the question here tonight, who authorized that settlement? So there should be somebody who's held accountable, whether it's our council or administration, quite frankly, right? So we just need to know that answer.
Well, if I may speak to it, council holds the answer. Just as we're an incorporated municipality, just as a board of a corporation, the board makes the decision. So it would have been council that would have had to have put the settlement to a vote.
But where is that? Like,
Well,
where is it
I don't
recorded?
see any minutes of it. I don't see anything on the record of it. That's why I cite that, in fact, this may have been an unlawful settlement. This may even put at jeopardy Ms. Karen Whitman of Myers-Weinberg, who represented and signed off on the settlement by some authority. And did she do her due diligence? Because under the Law Society, she needs clear, unequivocal advisement for the settlement. And if she signed off with an unclear directive from council, especially by vote, then who authorized her to sign off? She could be at jeopardy in front of the Law Society itself.
I think we're treading on pretty thin ice there.
Not really.
We are. You're making assumptions there. We
No.
never make assumptions there.
No, I'm talking
Our
Law
lawyer
Society.
our lawyer does not do anything until she is advised of her client's wishes with regards to this, and her client will be our CAO, who is the one person, the point of contact, who does the administration. It was council's decision when we had all the facts brought to before us there to agree to the settlement.
So
Where is the public record of that?
Well, this was maybe the CEO can talk more with
So no
regards to
resolution
dates.
is required in that case. So council was provided with the information and they directed me, and I signed off on that settlement. So it wouldn't be the lawyer signing off on that. I took direction from council and relayed that to the lawyer.
But
So
this
council
lawyer did
resolution
sign
is
off
not.
because she was responsible for filing the documents in the King's Bench.
But she does it under our direction. She works for us. She works for the Arm of Springfield, and there's got to be a point of person to contact there.
So in such a
It
case as
can't be
this, We have a CAO making the decisions
No.
on such a
No.
serious matter of theft.
She did not.
$2.2
That
Not
was-
at
million.
all what was stated, no.
It was done through council. Council agreed. We had many discussions with regards to this there, and all the facts are in our
What
brief
if a member
here.
of council comes forward and says they
Edwin,
didn't agree?
Edwin, can I talk? Okay, so we we were informed through our
Who is
lawyer,
we?
council. When I say we, the council, in this pretext here. So we as council were advised of the facts with regards to the case several times. And then when it came down to the last days where we can go to the mediation part there, where Chabot is on one side, then we're on the other side there, agreeing to the facts there. We came back to us. The lawyer had given her opinion. I'm not talking for the lawyer. I could just say that we agreed to the facts and we felt that it was the time now to take what we had, the 200 plus $1,000, and that was the feeling of council, and that was our direction to our CEO to give the direction to the lawyer.
Was council informed of all those materials, all that information prior to the registration in the King's Bench?
Yes. Registration at the King's Bench happened after. This was all the facts were done in advance there, so we were kept abreast of all the details with regards to how it was going through the civil routes there. So we were made aware of that through our CEO, and that's how the chain of command goes when it comes to this situation here. It was not the CEO's decision; it was council's decision. We advised her of that. Our CEO advised our lawyer. That was the direction. The lawyer does as she gives her advice, and we can either take it or not, and then tell her to go with our direction, and we took her direction. She's a lawyer. She's quite adept at the situation there. We had people from Public Works that were present there to give the facts with regards to aggregate there. And that's it. And it's very well detailed in our briefing note there. All your questions there are well detailed.
Well, I still want a copy. I've got a FIPA in,
Yeah.
42 days and running, and I want a copy of the settlement. It's up to you what you guys want to do with it, or the CAO, if she wants to deflect or obfuscate or say there's no record of it. That's whatever. I will deal with that in due course. And as far as in such a serious public asset situation, such a circumstance for the CAO to have absolutely unfettered discretion
She doesn't.
appointed to her by council, that will remain, that we can agree to disagree at this point in time. We shall see what certain technicalities may disclose.
Okay.
And I do hope, Mr. Mayor, your declarations here that every member of council agreed to this settlement prior to even the King's Bench filing that the lawyer implemented holds true for the record. I sincerely hope so.
And this is the same council here. When I'm making the statements, the same council is here.
Well,
Councillor Miller?
Thank you, Mayor. So, as you know, Mr. Giesbrecht, there was no real resolution in public as such. So I'm just somewhat concerned the mayor may have shared a little bit too much information that was perhaps and may have been in camera. So I'm not sure that should have been disclosed. But having said that, you can probably assume that if he's saying what he's saying, and I don't want to speak for him, so he should explain it, but if there was consensus by council that wasn't in the public forum, then where did that come from? Where did that decision come from, right?
well, I understand in camera, and the Manitoba Municipal Act is pretty clear on the sanctity of the informations for councillors in camera or closed doors. However, at the same time, you may be able to deliberate in closed door or in camera, but you cannot make a decision. It's black and white under the Municipal Act.
I would ask our CEO, is that how you would?
I would ask our CEO, is that how you would interpret it? In other words, decisions can be made in camera or they cannot?
Negotiations were discussed in camera, and I got a benchmark from council during that discussion, and that's how we went into the mediation. So no resolution was required at that point.
Any other questions? We got 2 other delegations to go.
Well, the only thing that I would question is that would it be the CAO's opinion that benchmark or no benchmark, having proceeded through to what you're referring as a mediation, it was not a mediation, it was a dispute resolution. That's what it was. It wasn't a mediation at all. No, it's not half of one and a dozen of another. It's very clear, and that's why it's identified in the courts under that dispute resolution. And that's why a separate judge was set out for that, because that way he would not be contaminated in the event it still went to trial. That's why. And so to say that there's a benchmark and you went into so-called mediation, but actual dispute resolution, that was a decision. That wasn't a benchmark. That was a decision in camera.
Okay. Any other questions from council or Councillor Kaczynski?
Yes, I would like, thank you for your presentation, Mr. Giesbrecht. And I would like to advise the public that I myself went to the court that day then there was settlement negotiated. And I was advised by a lawyer that represents the municipality that I shouldn't enter the chamber that the discussion gonna take place.
Okay,
So-
so are you asking me to speak to that?
No.
No,
I
I'm
think
just making
the
a statement.
question- So council was advised that we had to submit a participant list for that session in advance. We discussed it with council. Nobody talked about wanting to attend. We submitted our list. And so you couldn't just show up that day and expect to be let in. So that was the advice that the lawyer,
We wasn't advised that there was a list that we have to sign on to it. I never heard about it. I just, when I discussed with you, Colleen, I said that I want to go to the court and you said, you're too late, you're not on the list. I said, well, I never was advised that I have to sign some kind of list and put my name on the list because I want to go. I was prepared to go to the court and listen what was happening. And the lawyer stopped me and said, no, you cannot go to the room. That's just what I want the public to know. And a lot of things, what was happening, it was in camera and we cannot discuss at this point.
Well, that's understood, but I think the
Thank
Law
you.
Society should know about this.
That's your purview, Mr. Giesbrecht.
It is. Thank you, Mayor.
Okay. Any other questions at all? We can move on. Thank you very much, Mr. Giesbrecht.
Thank you,
We'll
Mr.
move
Mayor,
on.
for allowing
move
this delegation. That's transparent, open, and that's fairness. Even the hard questions sometimes are hard to deal with, and I thank you for that accommodation.
Thank you, Mr. Giesbrecht. Then we'll go to Mr. Page whenever you're ready. So, Mr. Page, you got 2 delegations here, 10 minutes each. So whenever you're ready to start on your first one.
Sure. No, sounds good. I will begin.
Okay.
So I'll be starting with my first delegation. My first delegation is involving the minutes and some other related matters to the minutes that I was hoping to speak to council about, but this is my first opportunity to speak to council. So you may have a document, maybe, possibly. If not, I'm going to be going through some certain items that are going to basically go down the agenda of tonight by item. So I'm going to start at item 6.1. So that is involving the March 28th. Oh, sorry, I should introduce myself. Did I? No, I'll introduce myself. Sorry, I'm just got a lot of stuff here. I got stacked. So my name is Dr. Daniel Page. I'm a local computer science professor on Pine Ridge Road. So I'm here speaking about the accuracy of minutes and procedural concerns. So item 6.1, so back to what I was saying. So on March 28th, 2025's minutes. So do note that this is technically a typo that also exists in the agenda. It refers to Charter Advocates Canada as Charter Advocates of Canada. The word of should be removed, presuming that you can modify the titles of agendas by fixing them. But that's just the first one. So do note it's called Charter Advocates Canada, not Charter Advocates of Canada. So it's a very small detail. So that's item 6.1. Item 6.2. Now this is a matter I want to be very careful about because, as you know, I've been documenting municipal meetings now for months. I spend a lot of time trying to do that as an academic service to my community. And I have concerns around April 1st's meeting. I reviewed the minutes, and on pages 6 through 8, there's matters involving items 13.1 and 13.2. Now, in the minutes, it says that each of these voted were marked as defeated without any further note indicating an event that for which this was declared. The chair stated that each vote carried, for which I provided sources. Now, just for clarity purposes, I should note that technically speaking, as the vote happened, it's at least my opinion, that it is indeed the fact it should be defeated, but that's citing the Municipal Act, citing 84.14 subsection B, which says a resolution to sanction a member under the Code of Conduct must be affirmed by a majority of the members for a council with fewer than 7 members. So in my document, I do have a bunch of evidence that this is in fact what exactly happened. So you got to keep in mind why this matters. So the public has no record that the chair declared these resolutions as being defeated on April 1st, 2025, or at any future point at this time. The minutes should document what occurred at the meeting. My concern is if these resolutions were actually defeated by a later determination of procedure, that should be corrected in a public record without inaccurately documenting the April 1st, 2025 council meeting and what was stated by the chair. I attended every public arms Springfield council meeting between April 1st and now. Should there be any further matters not disclosed to the public, it should probably be briefly noted properly within minutes to accurately document what happened and how council resolved it. It is good news to hear if these resolutions were decided later to be defeated, as a procedure error seemed to have occurred. However, that's not what was stated by the chair on April 1st, 2025. I understand this is a fairly meticulous detail, but having accurate documentation matters. If these resolutions were defeated, that should be made clear to the public, as that was not what was declared April 1st, 2025, nor was it information given to the public at any meeting I've attended. So that's item 6.2. Let's move to item 6.3. So specifically, this is involving the financial plan hearing. Now, I had some concerns because some of my things I said during the public hearing were oddly omitted, and I had some other concerns. So under item 4, for the financial plan hearing, there were some important omissions. Highlighted are 2 concerns. So I offer an explicit improvement for the document in the first of the 2 cases, involving my own concerns not reflected in the document. So I provided a very specific time in my video for which I documented the meeting, but I'm just going to summarize this. So Page did not just seek clarification about these costs, and I was referring to talking about a particular item in the financial plan. He also spoke opposing what he believed were high costs for conventions or conferences. The one he emphasized the most was costs of conventions and conferences, where there was an explicit exchange between the CFO and Page on this matter, giving a recommendation. So my recommendation in this case is to add a sentence between where Daniel Page asked for and the other sentence being he noted, stating, Daniel recommended that if the cost of attending conventions or conferences seem to be increasing, then conferences or conventions should be attended less regularly. So that was the first of the 2. The second one is I do recommend council, if they have not already, to carefully review Janet Nyland's comments during the public hearing. The present paragraph is omitting in its summary parts of what she said to council. She expressed several other concerns during the public hearing than what is documented here. To the extent I'm recommending you revise that whole paragraph. You may review specifically her portion. I give a time for which to review it. So keep in mind, I believe believe Jen Island may be in attendance, so you can always ask her own view about that if you would like. But I'm going to now continue here. So it's worth noting that there are oftentimes in minutes where attendance is counted. One suggestion I do have to help improve documenting that is suggest giving the time for which the recording happened. Because sometimes the number can vacillate, such as at that meeting it did. So now I'm going to be moving on to, so how much time do I have left? 3 minutes? Okay, excellent. So next I'm going to be moving on to item 6.5. So this is involving the May 6th, 2025 meeting. So this is the last council meeting. So this involves matters surrounding page 2 of the minutes titled Adoption of Minutes. It appears that there's an outstanding item, namely the approval of the agenda of May 6, 2025. So just for clarity purposes, there was a vote to approve, a vote to approve the amended agenda as a whole did not occur on May 6th. Only the following resolution carried in relation to the agenda. The one in question was, be it resolved that the agenda be amended to defer the March 28th, April 1st, April 22nd, and April 29 minutes to the May 20 council meeting. Immediately following this resolution, the chair proceeded to move to council reports. That is, council approved an amendment to the agenda, but did not adopt the agenda itself on May 6, 2025. So I have 2 questions. So keep in mind, there's a lot I've talked about here. I'm happy to discuss any of these things, but I have 2 specific questions. So the first one is, the Arm of Springfield has especially since the matter of documentation issues has become more frequent. For the purposes of the public, because I've been getting questions about this, when it does engage in its present practices for which it may defer or delay minutes, can it be clarified what convention is being followed when it does? This is to clarify how previous meetings minutes being approved or may be impacting the proceedings of a current meeting. So that's my first question. The second one is, at the May 2025 meeting, the CEO said that the only way the meeting could continue was to adopt the agenda, but then didn't ensure that there was a motion that accomplished this. How does the Arm of Springfield proceed with a meeting without approval of an agenda? That's all I have to say for the first delegation. Thank you.
Okay. I don't know where to start. We've been through this many times, Mr. Page. Their minutes are just minutes there, and we've gotten direction from our municipal relations, and we've had our minutes like this for, I would dare say, decades upon decades. And just in the last year, we've had some very in-depth inquiries by yourself, and that's a good thing. But I can tell you, nothing's changed from the other times you've asked that. Minutes are a brief narrative of what had occurred. The audio is the on the record for all the facts and what has been transpired in the chambers on that particular date. You used the word evidence. So there is no evidence here. This isn't a court of law. You do say why things matter. It's about keeping things on the record, and we have that, and that's all under the audio. You mentioned something about attendance there, and I do believe there was only one time where there was attendance made, and I believe that was for the financial plan there. And I'll stand to be corrected there from our assistant CEO or our CEO, but I'm not sure how we can make that any better, and nor do I think it rises to a level why we would even address the issue. This is what we had in front of us at the beginning. I think the number was 16, and whatever number was below that had left there. So I don't know how more simple a thing could be that we want to make it any more simpler. To make it more complicated, I don't think it resolves anything. We have a number there, and that's simply it. As for the adoption of the agenda there, for your question too, I'm trying to remember that the date there, and frankly, I can't. We proceeded through, so these minutes will be coming up under items 6.1, 6.2, and 6.3 and 4. So that's all I can really say. Anybody got any comments, council, or questions? Councillor Miller?
Thank you, Mayor. Thank you, Dr. Page, for your presentation this evening. I echo with you, and I still stand strong that minutes are legal instruments. Minute book is held by an organization because it's referred to if there's ever any legal challenges, that minute book is the record. So you've got some wordsmithing changes, which are very easy to do. Charter Advocates Canada, we can, I would suspect, change that very easily. You cited, of course, Municipal Act 84.142, where, in fact, the mayor was in wrong judgment in saying that it was carried where it was defeated. So there's just some errors and inaccuracies there, no question. In terms of the agenda item, it wasn't passed. So again, that's an error. Who's responsible for that error? Well, one can point fingers. I would not want to, but you know, we are humans and we do make errors for sure. So it was perhaps an oversight, or maybe it was in the pressure of the moment. I'm not sure, but we definitely need to do better on that. Absolutely. You know, what you're suggesting here is not to rewrite the minutes or put them in a style that's reflective of yours. Rather, what you're saying is we need to document these things more accurately. And I think that's your big thrust here, is accuracy is everything. Absolutely. And certainly the mayor knows, and RCMP notes and everything else that he had over the years of his experience, career, that if he does a faux pas and a name or an address or a time, that can be thrown out of court like nobody's business. And so I think that's absolutely critical and important. I wanted to share with you too that actually I'm going to ask the CEO, because the mayor refers that the audio recording is our go-to document. So how long are audio recordings held by the RM? Can I go back to 1975? Can I go back to 1992? Can I go back to 2012? Can I go back to 2018? How long are these audio recordings kept?
So no, you can't go back that far for audios. We weren't recording back then. It's not a requirement. It still is not a requirement. We do it as a courtesy for residents that can't make it to the meeting. So obviously, yes, you are going to hear word for word on that audio, which is available to the public. Minutes are not a legal document. They are not to be verbatim, and they are only supposed to note the decisions of council and general comments. That's how we write our minutes.
Okay, so I would, yeah,
If I may, Mayor, thank you. I would ask then, who is accurate? The mayor says that the audio recordings are there and frankly should be used as the instrument, and you say, frankly, they're there as a convenience. So as I've always been advocating, we're behind the times in terms of, we have a team here in electronic technology and so forth. We could be doing Zoom meetings live, as so many other RMs do, and for whatever reason we balk at that. We don't do it. I think we should have a better system to record. And the reason is because we're getting into so many dangerous zones here. It's he said, she said, she said, he said. You know, it's come and go. It's, you know, he carried it. The notes don't carry it. So frankly, we don't know if we're coming or going half the time. And I'm not putting the onus of the blame on you. What I'm saying is, my goodness, as a council, we can do things much better than what we are doing. And we just need the majority of council to agree with that path. If not, in a year and a half, we will. So again, I think Dr. Page has some very good information for us. He's not rewriting it. He wants accuracy, as all of our people do. If I sent out a note to my constituents and to the rest of people in Springfield, they would say the same thing. We've got to do better as a council to be more transparent. And if the mayor says one thing and the minutes say another, like who actually, what's accurate? I think everybody would be perplexed. I don't know if it's this or that. So an audio recording, I've heard issues from our residents too, that some of the audio was not performed well. Obviously we have issues mute and not mute, and what's heard and what's not heard. You know, again, look at municipalities like next door, East St. Paul and others who have you know, these recordings that are easy to see, and I've watched the East St. Paul Council numerous times and others. So are we so scared to face the camera and have accuracy, and then go back and see whose word, whether it be black and white or in audio, is actually right? So on audio, we have the mayor saying it's passed. In black and white, we say it's defeated. So that's what I'm trying to say is
Well, the resolution overrides what the mayor stated, obviously. So
Correct.
the resolution is correct, vote was recorded, and it was defeated. So that's what the minutes are accurate for that. So it doesn't override because the mayor said passed.
right. But even faux pas like spelling, things like that, for Canada, that might be a token thing, but the agenda not being passed. So where are we in a bit of a pickle? We didn't have an agenda, as I understand, passed on that date, did we, Dr. Page?
Which date?
You were referring to, I think, May
May 6th?
I think so. It's in your notes here. You said
Yeah, May 6th. Yeah, there was no agenda approved.
Yeah, so
So the agenda was amended and voted on. You're correct, it doesn't say approved. So it's missing that word, but at that time, council should have called a point of order and called it out and not proceeded with the rest of the meeting until that was dealt with. That was not done.
I know you're pointing fingers at us, but I would actually point fingers at the administration to say that we're not.
Well, you're
doing
right. It was an unusual meeting. It typically doesn't take 3 resolutions to pass the agenda. So yeah, I admit I made a mistake and didn't have approved in there, but it was amended, council voted, and you proceeded with the meeting. So it doesn't null and void everything after that fact.
I guess my ultimate point, one final comment, is that I think we can do things better. We're not in grade 12. We're in university. We're professionals, or at least we should be. And so we can do things better. That's all my thrust and my point. And Dr. Page is just showing a whole host, another slew of examples that he's shown us before. So why aren't we getting this right, or why aren't we improving?
Okay, I think we're.
You're not unmuted.
I think those are all the comments there. Is there any other questions there before Mr. Page goes to 5.3 for another delegation? I see none. Then Mr. Page, whenever you're ready to go to 5.3, summary and immediate aftermath of March 28th, special meeting. Whenever you're ready, 10 minutes. I got loose leaf paper.
Okay, I guess
Loose leaf paper to write on.
I guess we'll get started.
Don't worry about that.
Is the clock running? Clock is running, Daniel.
Okay, I was just waiting to get eye contact.
Oh, thank you.
So anyways, I will begin now at this at 6:58. I've come to speak here. So I've reviewed the proposed minutes, special meeting March 28th, 2025. I've already provided you my comment around that in my previous delegation. This delegation is meant to clarify and help reflect the timeline of events that have brought us to this point. The matter that arose stirring me to give this delegation outside of not being allowed to speak or document with video at the March 28th meeting, as I was documenting this meeting as an academic and professor for his community. There was a remark made at the March 6th meeting that put some concerns, and for which I put my hand up, and I was not entertained when I put my hand up. I was not allowed to inquire. I'm just going to quickly recite that, and I'm going to proceed. So Councillor Miller had stated, and this is in context of an initiation of discussion about the video recording ban that's been initiated in this chamber. Councillor Miller said, "You can't make up the rules that aren't there. There is nothing written anywhere that prohibits the public from recording meetings. If there is, show me, please." For which the chair, Mayor Therrien, said, "Councillor Miller, I don't know how many times we've gone through this. You say it's me. It is not me. This is the decision of council. Council came up with a decision. You asked for a special meeting 3 weeks ago and it was defeated. Emphasize that. I don't know how much more clarity do you want? It was a discussion amongst councillors there and we had a proper democratic vote. We voted about this and talking, and then immediately referred to me, said, put your hand down, Mr. Page. We've been talking about this repeatedly, I would say for 2.5 years. As of 3 weeks ago, it was resolved and it was defeated. Someone coming in here and seeing this is hearing misinformation. Disinformation is what it is. So that is why I'm here to speak to you today. And I'm hoping that you'll be willing to give me time to speak to council, because I've been wanting to do this for a while. There still seems to be a clear disagreement between some members of council of what exactly was discussed, to the extent potentially factually events are being inappropriately labeled as disinformation. As I will summarize, March 28th meeting did not resolve the matter, and largely residents and council remain in almost the same position as before on an imposed recording ban in the chamber. That began more broadly in force following an incident on February 4th, 2025. So some background here. As council is aware, I've been concerned about freedom of expression issues in the Arm of Springfield, citing concerns of Bylaw 2410, and even when it was being proposed. I have been following carefully the adoption and readings of 2410. I've given several delegations on the matter, including about documentation in the RM, propagation of misinformation and disinformation by the RM Springfield's own standards in local press, and potentially within this chamber, and other matters such as the February 11th meeting. But never once did I discuss the matter of the video recording ban during any process of the readings of Bylaw 2410. Regardless, it should be evident that I take care of studying what happens in this chamber and try to document what happens here for the public as an academic service to the wider community. The Arm of Springfield had approved its Bylaw 2410, December 17, 2024. Shortly after the third reading in 2410, the first utterance by the chair claiming that the bylaw prohibits recording by the public occurred, but it was not enforced to the resident leaving the room with a sizable portion of the rest of the audience. In later conversations, these have occurred throughout winter, up in several times then, there has been some point, some interpretation or reinterpretation has been made, at least this has been alleged, but I'm not aware of when this actually occurred. I'll be seeking clarity about this at the end of my delegation. Upon hearing the mayor exercise the bylaw in this matter, I was a bit confused at that time back in December. Because I was concerned about possible restrictions, and I've already had that conversation in the past and fall with council. Now, prior to the meeting on March 28th, on February 4th, a resident, Karen Inslee, was recording my public delegation at the public council meeting in the public chamber where the events took place as outlined in the Charter Advocates letter, for which that is located in the agenda for the March 28th meeting, dated March 20th. I would ask council to carefully review what also occurred on February 11th at the committee of the whole meeting, as the same disagreement is still happening, for which no resolution to the disagreement happened. So as of March 11th, where I had not documented to what length the sign was there, a sign was outside the chamber that cited an inactive bylaw, a previous procedure bylaw 1026. I actually have a picture of that right here. So this sign, it's kind of hard to see because I'm down here too. So the sign that I'm pointing at in this picture, this was hanging out outside the chamber. This was actually there on March 11th. It was citing bylaw 1026, which is an inactive bylaw. For those that are not aware of the history of this bylaw, 1026 preceded 1708, which preceded 2222, which preceded our current procedure bylaw. So it's been up there and it's been we've essentially had a notice up there about an active bylaw that hasn't been active for a while. I don't know how long it's been there. I unfortunately don't have that information. But it said no audio or videotaping of council meetings are permitted without 72 hours prior approval from the chief administrative officer. For context, 1026, a now inactive bylaw, did in fact state this. It restricted recording by the public and media provided they give at least 72 hours approval. which that indeed is in there. It's 14.11 of 1026. So then, again, on March 18th, I documented a new reminder notice that was placed outside the chamber, stated the following, and I have a picture of that. So this is the picture that I took.
Put it in the camera.
So
I
this,
can see that, thank you.
so this notice was put there. It's citing bylaw. It's claiming. So please be advised that as per procedural bylaw 2410, no audio or videotaping of council meetings are permitted without 72 hours prior approval from the chief administrative officer. Please refrain from using electronic devices in the council chamber. Now, as somebody that's familiar with bylaw 2410, that is not in the bylaw. So it does not appear there. And in fact, that's already been discussed with you on April 1st. So I'm going to skip over that discussion. But it's worth noting that this actually changed within about a week. So March 27th, so this is the day before the meeting, that sign was gone. So it was at least by then. So it's worth noting that there was some change that happened in there, and it was discussed at the 28th meeting in March, why that was removed. So one concern I do have that did come up, I'm going to get into the meeting itself in a moment. So it's worth noting that on April 1st, Mayor Therrien had said there was nothing wrong with the sign and that he can ask the administration to bring it back without clarity of which sign, which raises a concern. Now, for a quick summary, so because I saw that there were some disagreements about whether there was a resolution or not at this meeting, there were two resolutions put forward that sought to amend the bylaw. So namely, these were 2587, 2588, and then there was a third resolution, 2589, which was to allow the public to speak to the agenda items at that meeting, all of which were defeated. So it's worth noting that for 2587, it was explicitly stated by Mayor Therrien that upon reading verbally the resolution once more, so essentially allowing people to video and audio tape, and I'm opposed to that. So that's just worth noting. And the other one for 2588 at approximately 10:47 a.m. So that was defeated in this one. The mayor alleged at 10:50 a.m. that it was the same resolution as 2587, which was just the one I discussed. Note that the proposed minutes reflect that they are indeed two different resolutions, and that was something discussed among council. So I just want to just make note of that.
1 minute left there, Mr. Page.
So it's worth noting. So every resolution at that meeting was defeated. Ultimately, no discourse happened beyond Miller's reading of the letter, and every member of council except Mayor Therrien expressed that they would allow recording in the chamber under various circumstances. So whether it be concerns about privacy, whether they wish to get approval or get permission, these are things that were discussed. There was only one individual among council that completely opposed recording, which is what the Charter Advocates letter was actually about. That was Mayor Therrien. So in conclusion, the majority of council supports allowing the public to record, but not universally agreed that is unconditionally supported for the public and the media. So just as quick aftermath, so I'm hoping that I could be given a little bit more time to talk about that aftermath because that's a part of this delegation. But it's worth noting that I did, of course, document, as I do, what happened afterwards. So I already noted about April 1st. So do note that I took note of all the meetings for which the chair of the meeting had imposed the recording rule, which, again, I don't know where it is in the bylaw. So it's worth noting that these occurred on April 22nd, 2025, April 29th, 2025, May 6th, 2025, May 13th, 2025. And it's worth noting, I have counts of all of the attendance numbers of all of these meetings. So if anybody has any questions about why this may matter and why I'm recording audience counts, that may matter, because very often there has been a hypothetical thrown up about how this might turn into a rock concert and something about 43 phones. But despite that, none of the recording attendance I have even meet that threshold. So it must be stressed, according to Charvick Advocate's letter, this issue hasn't been resolved. The substance of the letter seems to have not been heavily debated, and some authority by the chair is being exercised without any clarity of anything written in the bylaw. And I'm not sure exactly what is going on, and I'm a little concerned about this. So it's worth noting again, I have a lot of other things I can discuss, but I actually have a series of questions as well. But I'm going to stop here because I know that I want to be respectful of time, but I do have lots of questions.
Thank you, Mr. Page. Any questions from council? Councillor Miller?
Thank you, Mr. Mayor, and thank you, Dr. Page, for your presentation in this delegation. Freedom of expression is an integral part under the Charter of Rights and Freedoms. There's no question about it. That's why I've been a strong advocate on this council to always allow people to record, to do whatever they need to do, because this is a publicly paid public chamber, and it should always be that way, despite if others don't want it to be that way. You indicated on several dates that the mayor initiated comments to restrict recordings. I have to be honest with you, I should have interjected and did a point of order and say, we're out you get that ability to say that. In other words, the bylaw as it reads today does not exist. It is the media that needs and can seek approval, but Joe Public, or any member of the public, I should say, has the ability to record at any time here within this chamber. And so I'll ask you a question or two after, but I want to ask the administration, why did that sign come down? And I speak specifically about what Dr. Page referred to. There was a page, because I saw it too, and it was for a week or two or three, where it said, the public needs to seek approval. You have it as evidence, but why did that sign come down?
Well, the sign was not required to be posted up there. It was done just to outline what was allowed in the chambers. So the original sign was up. Then I noticed that it was not updated as per the new bylaw. So I asked staff to update that. I did not review it before it was posted. And the first opportunity when I did review it, it was not correct. So I said, just take the sign down until I have time to review it. Then I believe it was an email from you and said, thank you for taking down that sign. It was wrong and shouldn't have been up there. We just didn't put it back up because there was no point in putting it back up. The bylaw is the bylaw. We don't need a sign up there indicating what the rules are of the chambers.
Right. So thank you for taking it down. But my point was not whether the sign is up or whether the sign is down, but as our procedure bylaw does indicate very specifically, the public, as we were debating at one of our previous council meetings, the public does not, unless I'm reading it wrong or don't see it in the black and white, the public does not need approval to record in this chamber. And even if they did, and I'll let you respond, of course, but even if they did, that's what I would call a breach of the public trust, because the public should have the ability to record these publicly engaged meetings, specifically and even more so because we don't video record them. Our audio is sketchy, and our minutes, well, we can all judge to that. They're minimal, and so how on this great earth are people to really realize what's going on by any member of council or anybody who's speaking as a delegation if they can't even have the ability to record themselves? I don't see anything prohibiting the public to record at any time, anywhere.
So I don't know if you recall, but I did a history of the procedure bylaw. So our previous bylaws, we'd have obviously quite a few amendments because each council reviews the bylaw. So typically it changes every 4 years. Bylaw 1026 indicated that the public and media could audio videotape as long as 72 hours approval was made in advance. Then the next bylaw, 1708, changed that to say that the municipality will audio videotape at their discretion and post that on the website for the public to view within 48 hours, pending any issues with our IT. But media was still allowed to audio and videotape. So we purposely removed the public in that bylaw 1708 because the RM was going to be posting that audio and video for the public to view. So that's why we interpret it that the public is not allowed to audio video, because they were purposely removed once the RM started to audio tape and provide that.
But surely you know in law, and I know the mayor certainly does,
I'm
if
not
you
a
have a Highway
lawyer.
Traffic Act, and it says you can't do something, you can't do something. If it's void of something you can't do, you can actually do it. And I know that from law, that if it says you can't do something, you can't do something. But if you're referencing a bylaw here where it's extracted, in other words, you said the words, you're interpreting it. You know, in law, we'll have two lawyers and they'll interpret something radically different. And so my interpretation is it's not in the existing bylaw. The media, I should say, the public has should have every right to record. And if it doesn't, then we better make it that way. We really ought to make it that way. The public, do we forget we're getting paid? How many times do I have to say this? We're getting paid by the public. This whole building was paid for by the public. And on it goes. And we want to say, no, we don't want you here. We don't want you to record and make it difficult for them to hold us accountable. We're certainly not transparent. So all I'm saying is let's raise that bar. Let's do a lot better. I hate to be as negative tone as I am. I've never in my life had to be, but let's be positive. Let's make things better. Let's don't have these restrictions on the public. And don't refer to things in the past that were probably wrong. I don't know who instituted 1026 and 1708 and all the rest of it. I don't think it was us, but you know, perhaps those things didn't really, there was other motives and reasons that those members of council did it. And if I had any say in my own, I would be very, very discouraged by any council member today, tomorrow, or in the future saying to me or to any member of the public that you're not really welcome and certainly don't record. So let's be more positive. Let's create an atmosphere of inclusiveness.
So I think the point of me providing council with that history was then I also suggested you bring the bylaw back and clarify it either way, because it doesn't seem to be working the way it is.
I would interject. I think it's working fine. We have clarity in this. We had a special meeting 3 weeks ago, and the question was brought forward on resolutions there, and due process was adhered to, and it was defeated. Plain and simple. Audio recordings, video recordings are not allowed in the chambers here unless you have 72 hours notice given to the CEO. It's or 48 hours notice, and that's been adhered to. We had this discussion, like I say, and it was your request in the special meeting. Your two resolutions, I believe, that we had there, and it was defeated. Due process was adhered to. I don't know why we keep on having the same question there again and again. I'm not sure how we transferred from a delegation to this question all over again. That's been answered many times up until 3 weeks ago. And that's our procedural bylaw. We have this discussion, and in a year we can bring it back if you like. But I see no, I'm on a record there having, I think I said 43 cell phones, video cameras looking in the audience here. People are in the audience here. They're here to listen and to learn. They don't want to be on YouTube. They're being videotaped. If somebody is that wants to get a picture of my mug, and I've been on YouTube, I don't know how many times there. They're doing it now. I guarantee it. And recording from their homes. So that's nothing stopping people from doing that. We don't even have to do the video. We do it As a courtesy, we maintained it, I believe, through COVID there, where we had to have this. So we kept it up there. So the audio was a requirement. And again, I should actually have this all written down where I don't have to keep on repeating it and bring it up every 3 weeks there. I think this has been discussed, answered, and not, well, repeatedly. And Deputy Mayor?
Yeah, I'm going to speak to it. I believe it should be clear also, to be honest with you. I don't really go with interpretation because that is very gray and creates issues. I was one of the ones that tried to pass the bylaw with the 72 hours, as people know. I believe in structure. That I do believe in. So I'm willing to bring back the procedure bylaw with structure, not openness for everybody and everything. I want structure. There's a reason why we went to delegations. It's the reason why we're doing what we're doing. To me, it's working better. It could be debated. I don't argue that. There's people that will disagree with me, but I can share with you. Look at today. We only have 2 delegations technically, and we have open for 6 to 8 on every given council meeting. And I'll say it again and again and again. There's structure. I haven't stopped anybody from coming to council. If they phone me, I say, come to council, sign up as a delegation. You can speak to council anytime. Nobody debates that on a one-to-one base. That's where I come from, is I believe in structure. I believe that anybody can record as long as it's given the 72-hour notice. And that, again, I agree. I don't think it would, and I agree that it hasn't happened. I don't think we'll see 53 cameras up there videotaping us. I don't believe that. But at the same time, we still need the structure. That's where I come from. Thank you.
Thank you. So, Councillor Fuel, so now you're saying that people, if they put 72 hours notice, they're going to come, you're going to have 43 phones here recording. So what's the difference if they have to ask you or they just come and do it? So we be selective now. Oh, this person can do it, this person can do it, but this 10 person cannot do it. Like, doesn't make any sense. Doesn't defy the logic. So I don't even know why we're restricting people. Like this day and age, we're restricting people. Like everybody have cell phone, everybody using them public places. No, municipality of Springfield gonna be different because we know better. And I don't think so we know better because law is there. Law is there to protect people to doing things in the public places. And nobody can defy that. This is not said by us, said by the people who are above us. That's who doing that. Thank you.
Thank you, Councillor. Councillor Miller. Proceed.
Yeah, thanks, Mayor, and I will be very brief on this. I kind of get it now, your comments, and I quote, the public is here to listen and to learn. I see it quite differently. Actually, I see it quite a bit differently. I see it as I'm here to learn and hear the concerns of members of our municipality. So I think we have just as much to learn and to listen to the public, and you want to exclude them. So all I'm going to say in that context is that the countdown's on, and in a year and a half, we're going to have some changes. And this will be a significant election issue that I will bring forward to the public to see if they want me to represent them, have an open dialogue council, or if they want people to restrict it. And I will put that front and center among many other issues, but I can assure you that I will not stand for and I'll fight every opportunity that we restrict the public, because integrity, that's what we ought to be all doing. And just a question for Dr. Page, do you see us having some improvement with this? In other words, what's your feeling that your advocates would come down in terms of their decision if they were to make a decision? Are we following the Charter rights and freedoms? Are we giving people the ability to express themselves? If we're just here listening, or for the public, as the mayor says, to listen and to learn, I don't know how that is freedom of expression. In other words, shut up, you'll listen to us. I don't think that's right.
Sure, I'll speak to that. I just want to remind the chair that I did intentionally stop because I did have a list of questions. But I will answer your question. I'll try to be careful and concise about it. So I'll provide a bit of mixture of my experience and also my concerns wrapped up nicely in a very simple logical argument that I could provide just so I was trained in that way. So first, I should mention that there was discussion about changes so people have to get approval to record. It'd make it very difficult to communicate that to the public. Because they would see somebody recording and somebody else would see them recording, and it'd make it next to impossible for them to tell the difference. Because they'll see somebody recording in this chamber and be like, oh, I can do that too, because they've seen the other person doing it. And they would have to remind them all, and then you have to have some sort of, it would turn into a rabbit hole mess. And I think that would just create more chaos as far as I'm concerned. I do appreciate the comment about structure. I think it is important to have structure in a meeting. But now I want to talk briefly about the fact that you're kind of stuck into a logical trap at the moment. So I'm just kind of trying to explain this. Because on one hand, if the interpretation is correct that recording is being banned in this chamber, then Charter Advocates has a valid point to go against this RM. Like that's their argument. If it is the case that the chair is acting without an authority, then that's also a problem because he's supposed to be acting by bylaw resolution. So there is no win in that situation. Because in one hand, if we're currently interpreting the bylaw in this way, then their letter, they have their opinion and they seem to have their covered. They seem rather covered on some of their any concerns. I don't know, but this is just what their opinion is. And I was very dissatisfied to see that there was no substantive discussion about this other than the reading of it. And when in reality, there's a lot of concerns right now. Residents feel like they can't come here and talk. And I've been documenting the meetings for the public, and many of them come and say, thank you for doing that because I can't come. Maybe they're like a young couple, younger, not like super young or anything, but many of them appreciate the fact that that's available to them because they don't get access to those videos because, like I've said, that the RM doesn't have that. It's a convenience. But I also must stress, as a professor, I've been very concerned about the truth-based claims being made in this chamber because several times I hear, as it was echoed by first delegation, appeals to minutes, then likewise appealing to audio recordings, when in reality, audio recordings aren't a reliable tool in the first place. I've documented this many times over. And I've spoke to council already about this. Likewise, minutes are supposed to be what should happen. But when it comes to this question of like, are we doing is this chamber something that seems to be reflecting the value of freedom of expression? Which I must stress, there's a legal context of it, and there is this broader one. I'm just saying, there's only, how many people here? We got 4 people and myself. My attendance numbers are down compared to how they were since the procedure bylaw passed. And again, I'm left with a lot of unknowns. I do have a bunch of questions I'd really like to ask because they're really valuable. And as a researcher, I really want to get them out there because I've had residents reaching out to me to get information. And this is my opportunity. I can do that.
Well, you had your time. We gave you extra time. And you answered the question from Mr. Miller, or Councillor Miller. So to try to interject now to give us the questions there, you had 10 minutes like everybody else, so you should have utilized your time accordingly. So now to say that you have a bunch of questions, you said it in the beginning there before your time was up, you should have asked those questions. How many questions have you got?
Well, I can pick from my subset of 9, but I did have
9
one I gave
questions.
at the very beginning of my delegation. I asked for, so I'm not sure how many as chair you'll allow me to give.
Well, I
but
tell you
there
what,
is one explicit
Mr.
one
Page, Mr. Page, you had 10 minutes, like Mr. Giesbrecht has had 10 minutes, and everybody before you. You've had delegations before where you do the same thing, where you ask for more time at the end. You got a 10-minute window, use your window well. Maybe I would suggest if you got a delegation and you want to do a time thing, press the clock and see how it is. Do a rehearsal. But to end it off there and say you got the 9 questions there, you can put your hand down. Put your hand down. Or you keep it up if you like. So the point is that you had the 9 questions. Why didn't you do that at the very beginning?
So I guess I'll answer your question because you're inviting me to. So to answer your question, I already actually invited to answer a question. I said I would look for that at the end. So actually I did put a question out there, at least one in my list. And I did intentionally say I was going to stop just so that you would ensure that I can get time to ask questions, which I think as a chair, it's a decent thing to respect. And two, to patronize a professor like that's not respectful. I put a lot of time into this, and I appreciate if you respected me better.
No, I respect everybody the same way, whether you got a PhD or whether you're somebody that's collecting garbage. You get the same thing. They got 10 minutes. Mr. Giesbrecht had 10 minutes. He adhered to it, and I guarantee he did a time check there. You're saying that you had 9 minutes at the very end. This is on you to have those questions. The 9 questions there, how many minutes is that going to take up, and how many times, and are we going to have to answer that? And we're already at 7:30 here.
So
So how many questions have you got? You were telling me that you whittled away from 9. Now what are you at?
So just to clarify, I didn't say I had 9 minutes. I didn't say
9
that.
questions.
I had 9 questions. So there's 2. Is it okay if I ask 2 questions?
Go ahead. 2
Okay.
questions.
Hey, one of them will be one I already said earlier.
Okay, Mr. Page, you have 2 questions. Is that what you're saying? Okay.
So I'll ask you 2.
2 questions. Okay.
So question 1, I attended every meeting relating to the readings of Bylaw 2410. When exactly was the conversation where this interpretation of no recording unconditionally was made?
It's in our procedural bylaw. When it was done the last time that we looked at our procedural bylaw 6 months ago, would I say there? That was 6 months ago.
Okay.
It's dated on the bylaw.
So because I'm hearing of this. So the last question I will ask, because I've been asked out of courtesy to ask this, just because I'm trying to get information for people. So has our RM had any conversation with another RM about this matter in any capacity?
For what? The
recording ban. Your recording ban.
Yes, I believe we've had lots of conversations with lots of RMs there with regards to recordings. I can't say how many I have, but are you asking how many have the ban and don't allow it?
I'm asking, so has our RM had any conversation with another RM about this matter in any capacity? And if so, could you name them?
I've had many discussions with other RMs, and I can't tell you who they exactly are, but the vast majority don't have recordings allowed. City of Winnipeg is one of them there. I speak with Mayor Gillingham, and I believe there is another one that we were discussing not too long ago. Bigger centers, that's not the best, if I can tell you.
Okay, no.
Councillor Miller?
Thank you, Mayor. As you know, Dauphin is just repealing their bans, and the City of Winnipeg actually is pretty open. They record their meetings, so I'm not sure you may have spoke to Mayor Gillingham, but I watch those meetings, and I very clearly see that the recordings are allowed. But actually, Mr. Mayor,
no, I'm sorry, Councillor Miller. I'm talking individuals in the audience.
Yeah, and people do actually record at the City.
Oh, I'm sure people sneak it in that way.
But actually, what I just want to make 2 comments. Dr. Page, again, thank you for your questions. If you have subsequent questions, I would ask that you either submit them to our CEO or council. But I'm just a little bit disappointed, our mayor, at how he reams you out. It doesn't show the respect that I would want if I was a member of the public. And I would ask the mayor, does he call his doctor by his first name as well? Or do you actually call him doctor? Because, you know, this person who is in front of us has a significant amount of education. If I go to your doctor and say, hey, Joe Blow, I think that would be horribly disrespectful, as you've done to Dr. Page here today, because you call him. No, I'm just saying, that's my opinion.
Okay.
You've done it multiple times, so you don't respect his degree nor his specialty or anything else. But if
Can I answer that?
if somebody is, can you imagine if a resident went up to you and said, hey, Pat, when you were on the beat, instead of sergeant or commander or whatever you were, chief, can you imagine you or me saying to the chief of police, hey, Joey? I don't think that would go over very well.
It's fine. People, and I've had, absolutely, you asked me a question, if it was disruptive or disrespectful to me, calling me Pat. They did it to all the time, and all the different reserves I've been at, call the chief by Roddy or Peter. There's no disrespect there. And Mr. Page, it's not disrespectful that I don't call you by Dr. Page. The doctor who saved my life months ago there, I call him doctor. It's not disrespectful to you by not referring to you as doctor. It's not done disrespectfully. So I don't infer that I call him Mr. Page. I call my doctor, I call the doctor that saved my life and saved other people's lives, medical doctors. That's just the way I am, is a medical doctor I refer to as doctor. It's not disrespectful by calling Mr. Page, Mr. Page. If that's just me. So I don't find that that's disrespectful. It's no intent to be disrespectful at all.
It's okay if I just clarify why I said that. Just to clarify, it was about the treatment of myself, not the formal title. But
In today's proceedings?
Yes.
Well, I would agree. So maybe I was a little bit strong. But the point is that everybody else here has time set. And you've done it before, Daniel, there where you didn't have the time restraint there. And I understand that not always the case, but you're well into the tooth there, and you still had 9 questions there. You have to be prepared in that time frame there. So I stand corrected there if you took it out of disrespect. It's not. It's a bit of chastising, but everybody else here comes here prepared with 10 minutes, and they utilize their time. We gave you extra time on top of that. So I apologize if you took it wrong. It wasn't meant to be disrespectful. Absolutely. And whether I could refer you to as Dr. Page or Mr. Page, no disrespect there. Councillor Miller asked me do I refer to you as Dr. Page and so on like that? My understanding and how I was raised there really was no, someone's got a PhD, which that's what you have. They have a PhD. Doctors are referred to the medical doctors. That's the way I was raised there, and it's no disrespect into the Page family. I knew your dad quite well. It's no disrespect to not call you Dr. Page. So maybe I'll try to call you the Dr. Page, but it's not my thought there to call the medical doctor, like I say, saved my life. He's doctor. They're the medical doctors. That's the way I am. No disrespect. I hope you take it that way.
No, well, just to clarify once again, it wasn't about doctor, it was about the treatment towards me. It was the way your tone was towards me when
I just said that.
Yes, I know.
Your tone was enhanced. I agree. My tone, I should say, was enhanced. But you got to come prepared. That's what I'm saying. Okay, any other questions?
I did come prepared.
Okay, any other questions from council? Councillor Kaczynski?
Thank you, Mr. Mayor. I want to remind you that I attended a lot of meetings being a councillor. All the meetings I attended, nobody say no recording in this session. Never happened even once, because it's public meetings. Why it's happening in the municipality of Springfield? Can somebody explain to me? And you know what, like you stated that you talk with a lot of people about recording. Why are you preoccupied with recording? I go to the meetings. I have very other issues to discuss with the other councillors and mayors and reeves. I even don't think about asking questions about recording because it's not a very important. It's a public place and people can do the recording in the public places. That's why nobody specify on all these meetings. You cannot record. There is no signs, no matter rooms or whatever we're going. So obviously that should tell us something, and we should learn from it. Thank you.
Thank you. Any other questions? I see none. Thank you, Dr. Page.
Thank you very much.
Then I guess we'll proceed to I gotta find my papers here. Adoption of the minutes. So if we can go to 6.1, that's the special meeting minutes of March the 28th of 2025. Can I get a mover and a seconder for that, please? Deputy Mayor Fuel and Councillor Warren. Was there any questions or comments with regards to this? Councillor Miller?
Thank you, Mayor. So I would take what Dr. Page said today and incorporate those. Otherwise, I'm not going to support these. Obviously, there's typos and there's other important elements to those minutes, and as they're written right now, they don't reflect those.
Can you just remind me what typos? I didn't catch that.
Well,
Advocates.
Dr. Page has a handout. I think he could probably provide you, but 6.1, if I
Well, I only understand that we put Charter Advocates of Canada and there shouldn't be an of, but are you saying there's spelling mistakes on the March 28th?
yeah, I think you would want to refer to his notes. I can't rehash everything he's said.
That's why we usually request information ahead of the delegation so we can prepare for these.
Yeah, I think Dr. Page did provide it in advance, didn't you? Yeah.
That's different than what we got here?
So the only request is to remove of. It's to
Advocates.
remove of between Charter Advocates and just Charter Advocates Canada.
I think of the March 28th, that would be accurate. Yes.
Okay, well, we can change that there. Any other questions, comments? I
Okay.
see none. So
Whereas
go
the
ahead.
minutes of the special council meeting held March 28th have been previously distributed to council, be it resolved that the same be and are hereby amended as follows. Amend 3.2 to remove of to Charter Advocates Canada.
That being read, can we get a show of hands of those in support of 6.1 special meeting minutes with the changes or change? That'll be unanimous and is carried. Then we'll go to council minutes of April the 1st, 6.2. Mover and a seconder, please. Patrick and Melinda. Any changes or corrections on that, council? Councillor Miller?
Thank you, Mayor. Again, alluding to Dr. Page's comments in his submission of April 1st.
And as I explained, like the mayor's calling it passed does not supersede the vote, and that the resolutions are defeated, and that's how it's recorded in the minutes.
Yeah, well,
Changes made there. It's already been made.
yeah, I don't like how they reflect. That's fine. I'm not going to discuss this. Dr. Page gave us a good deal of information why they need to be accurate, but I just won't support it as it is. That's fine.
Okay. Any other comments, council?
Well, I don't know, you can't amend the minutes to talk about that this happened after the fact, correct? So the minutes are what happened that evening. And the vote of the resolution is showing defeated as it should.
Councillor
I would
Kaczynski?
suggest that we just put what happened on the meeting and then amend the minutes in the meeting or whatever was said on the meeting.
Well,
It doesn't even show that the mayor indicated it was passed. So what's the point of putting in that it was passed just to confuse that the resolution says defeated?
In the audio, it will show that
And that'll be on this audio explaining it.
yeah, I think there should have been a note to those minutes indicating that as you actually alluded to, CEO, that a member of council or yourself should have interjected and said that that was out of order or that wasn't procedurally correct. And so having said that, that's fine. I'm not going to win this argument.
Well, it's not an argument, Councillor Miller. We have changed it to the defeated there. And that's the background for the minutes. The audio will reflect it, what exactly happened during that meeting there. I guess we just had our presentation from Dr. Page there. Any other comments from council at all? Deputy Mayor?
So I am in agreement with this, that what was stated on the audio is not recorded in the minutes. And the minutes are correct, in my opinion. So I'm okay with this because of that reason. We're not trying to make the audio to reflect the minutes. We're wanting the minutes to be the facts. Thank you.
Yeah, unless there's no other questions or comments, prepare to vote on that. If I can get the reading of, what is it, 6.2?
Whereas the minutes of the council meeting held April 1st have been previously distributed to council, be it resolved that the same be and are hereby approved.
Okay, if I can get the show of hands, those in support of council minutes April 1st of 2025 or 6.2 on the agenda. Those in support? That'd be Councillors Warren, Fuel, and Therrien. Those opposed? That'd be Councillors Miller and Kaczynski. It is so passed. Then we'll go to the financial plan minutes of April 22nd of 2025, 6.3. A mover, seconder, please. Councillor Warren and Fuel. Any questions or comments from the council with regards to that planning hearing minutes of 22 April? I see none. If we can read the resolution, we can vote.
Whereas the minutes of the 2025 financial plan hearing held April 22nd have been previously distributed to council, be it resolved that the same be and are hereby approved.
If I get a show of hands of those in support of 6.3 financial plan hearing minutes of 22 April. That'll be unanimous and so carried. Then we'll go to special meeting minutes of April the 29th, 6.4 on our agenda. Get a mover and a seconder. Therrien and Warren. Any questions or comments from council for special meeting minutes, 29th of April? I see none. We can read the resolution, we can vote.
Whereas the minutes of the special meeting held April 29th have been previously distributed to council, be it resolved that the same be and are hereby approved.
Can I get a show of hands? Those in support of 6.4 special meeting minutes? That is unanimous and is so carried. 6.5 council minutes of May 6th, mover and a seconder, please. Fuel and Warren. Any questions or comments from council at all? I see none. We can read the resolution, we can vote.
Whereas the minutes of the council meeting held May 6th have been previously distributed to council, be it resolved that the same be and are hereby approved.
All right, if I can get a show of hands, those in support of council minutes May 6th. That is unanimous and so carried. Just for the record, we had already gone through bylaws before Mr. Giesbrecht there, so we had a few minutes there. I guess we'll be starting off at 8.1. That's page 2 on the agenda. That's unsightly bylaw discussion. Do we need a mover and second for discussions? Any, this was defeated last time. I thought we'd bring it up here for discussion to see what the issues were the last time there. If anybody would like to start off the conversation, I know Deputy Mayor wasn't present for that, but what can we do to fix it or make it more appealable? Deputy Mayor?
Yeah, I'd just like to make a comment. I received a phone call from a resident that supports this bylaw because they're dealing with an unsightly premises next to them. And they just wanted to make council aware that them as a resident dealing with a situation in this case, they fully support us passing this bylaw. So I'd just like to share that with council. Thank you.
Councillor Kaczynski?
Thank you. I'd like to suggest that it's like complaint driven, this, you know, I suddenly bylaw draft because people have their stuff, you know, like living on a rural area, and, you know, some people like antique cars, and they, you know, have a maybe car that it's not registered, but they like this car. So, you know, if it doesn't affect neighbors, something like that, then I think they should be able to do that. Like if affect the neighbors and neighbors complain about something, so I guess they can make complaint to the municipal office, and then obviously a special authority, whoever we assign dealing with that issue, then they will try to resolve it, or, you know, maybe, you know, do something that they have to comply with this, you know, bylaw. Thank you.
And I agree with you, Councillor Kaczynski there, but we need something to go there. We can't just say, I think this looks unsightly there, unless there's a bylaw that we can go to that can show an infraction there that's enforceable under the Municipal Act. These bylaw, I think bylaw enforcement or enforcement under the Bylaw Act or something like that. We need something that we could say what is unsightly. That's a pretty arbitrary, not an arbitrary, but it's a subjective there. And I think one of you, Councillor Miller, Kaczynski, had mentioned something about it's up to the officer or the bylaw officer there, the discretion there. Last time, and I stand corrected if I misheard that, but we need that. There are Constable Zillman had mentioned the separation of making the two different bylaws there, and this one the unsightly, and I'm not sure what the other one was, unregistered vehicles, derelict vehicles. So we are separating them, and I think that was excellent advice from Constable Zillman there. To make them two different bylaws there. So good advice on his part there. But we need something there to that our bylaw officers can have a tangible bylaw to look at. I know, but I said it longer.
Yeah, just a little bit long. It didn't take your 5 minutes.
I don't think we've enforced that 5 minutes at all.
So I can confirm that right now we are complaint driven only. We do not have the manpower to be going out and looking for these issues. And if the neighbors don't have a problem, we typically don't have a problem. So right now we are simply complaint driven, and we still try to work with that property owner to comply on their own without having to go in heavy handed. So, and I think our staff do a very good job of that.
Then was there any other issues there? I think we'd like to bring this back for a first reading there. This is just throw it out there and see what there's any reasons why it was defeated last time so that we can make it better. And I see none, then maybe we could look at that if there's any other discussions that come to light after the fact, and send them through to our CEO, and then we can look at it there. But we'll bring it back sometime. I'm not sure when that will be, but we'll bring it back. I see no other questions or comments there. If we can move on to consent agenda, items 9.1 and 9.2, Manitoba Good Roads and AMM News Bulletin there. If we can handle them together. If I can get a mover and a seconder for 9.1 and 2, Melinda and Glenn.
Whereas a consent agenda has been submitted consisting of 2 items, be it resolved that the said consent agenda be received as information.
Thank you. And with that being read, if I can get a show of hands, those in support of the consent agenda. That's unanimous and is so carried. We'll go under new business there. Vernon Road dust complaints there. We just for the public record, we had a working group discussion on this today. And so some of the complaints there were mainly brought forward by Councillor Kaczynski at our working group today at 2 o'clock, and at our last one before that there. So maybe Councillor Kaczynski, if you wanted to highlight maybe to the public there what these complaints were.
Thank you. So we have complaint from residents, and apparently there is 40 residents that they have dust problem in the road. The backyards of these residents going to the road that it's very dusty. And municipality doing dust abatement, but with this hot weather and very dry weather, that doesn't help. So the resident complained too that some people speeding, like they're going 60 kilometers, well, only 10 kilometers over the speed limit, but you know that especially when the truck going by, then you know lifting the dust. And we discussed this in the working group, and decision was made that we put on a future plans, and we're going to try to apply the dust abatement as much as we can if it's required. It may gonna be costly for the municipality, but if those things have to be done. And in the future, probably this road gonna be paved. So we're gonna limit the dust that to the residents in the area. That's what I like to say. Thank you.
Thank you, Councillor Kaczynski. The price, correct me if I'm wrong, I think to pave that would be upwards of 1.5 million there, just for the record there. There's other different means that we were looking at, and so Public Works is working on this there. And we had a great discussion this afternoon with regards to that, and Councillor Kaczynski summed it up quite well. Unless there's any other questions, I see none. If we can go to 10.2, prohibiting engine retarder brakes, I'll throw that to Councillor Warren.
I had a resident talk about that. Actually, I've had a couple of residents right in the town of Enola, but this 10.2 is about Highway 302 and 15 and how there needs to be more signage because they do hear the engine braking, and it becomes a distraction. People try to enjoy the outdoors. So we are looking into that, and we are having meetings with, or not we are, but not council, but administration is going to be meeting with MTI in early June to discuss signage, speeds, just all that kind of stuff. Because, I mean, really, Springfield we've got Highway 206 and 15, we have 302 and 15, we have 207 and Garvin. We are full of provincial highways, so we do need to get MTI on board with proper signage, speed reduction for the whole area. We need some consistency along the way here because people don't want to listen to speeders going by, saying if it's a hot rod night on some road with their little cars. It won't be me. Me and my little SUV won't be running back and forth on roads. So we need MTI to step up here.
Thank you very much, Councillor Kaczynski.
Thank you. I would like to add that Highway 207 and Highway 213 should have sign prohibited from engine retarded brakes. People in the area complain, and I think that should be noted at this time too. Thank you.
Yeah, and I guess I can end off on this unless there's other questions there, but we did in our working group had a discussion there about after administration meets with the MTI next week or whenever that is, then we'll look at bringing forward a bylaw with regards to engine retarder brakes there, and that I'm not saying it's going to alleviate the problem, but at least a couple of signs. Resolution there. So once we have the resolutions adopted there, then we can at least have something to go on. We also discussed as part of this, it's never really the question that kind of evolves there about speeding reductions in that area of Enola, where we should move the signs back because we have the school there. But with the really good discussion that came across from that is that trying to make every area about the same in the RM of Springfield, and I hope that across the province there, where it's, somebody could go into another RM attaché or a broken head, and the reductions are different. They seem to not be the same length and so on like that. I see it's very difficult to do in discussions, but that was part of the discussions as well about a uniformity and the engine or the speed reductions coming into a major or centers of build that are built up. Any other questions or comments? Then I see none. Then if we can go to requests.
Sorry, I do have a resolution prepared for this. We do have to request that through MTI, and the RM is responsible for the costs of the sign and installation, and we expect that's about $500 per sign.
Okay, we're talking 10.3 though?
No, the prohibiting engine retarder brakes at 302 and
okay.
15.
So we have a resolution, you said, for
Correct.
that? Okay, could I get a mover and a seconder for a resolution on engine retarder? Councillor Warren and Kaczynski.
Be it resolved that Council of the RM of Springfield requests Manitoba Transportation and Infrastructure to install engine brake retarder signage on Highway 15 approximately 1 mile west of PR 302 and on PR 302 north approximately 1 mile north of Highway 15.
With that resolution being read, can I get a show of hands? Those in support? That is unanimous and is so carried. Then if we can go to 10.3, that's a request to MTI temporary installation of a speed display device on PR 206, item 10.3. A mover and a seconder, please. Councillors Miller and, Warren and Fuel.
Whereas the RM of Springfield recognizes the importance of traffic calming and improving road safety for motorists and pedestrians along PR 206, and whereas the RM has identified a need to temporarily install a speed display device on the east side of PR 206, approximately 650 meters south of PTH 15 in order to promote safer driving behavior in the area, and whereas the RM of Springfield is prepared to cover all associated costs for the temporary install, operation, and removal of the speed display device. Therefore, be it resolved that the Council of the RM of Springfield hereby requests approval from Manitoba Transportation and Infrastructure for the temporary installation of a speed display device on the east side of PR 206, approximately 300 meters south of PTH 15, with all expenses to be fully borne by the RM. And be it further resolved that a copy of this resolution be forwarded to MTI for their consideration and approval.
With that resolution being read, if there's no questions, I see none. Can I get a show of hands, those in support of 10.3? That is unanimous and it is carried. So then we'll go to 10.4. That's the vision plan there. Can I get a mover and a seconder, please? Therrien and Fuel.
Be it resolved that Council of the RM of Springfield approve the vision plan as presented.
Any questions, comments with regards to vision plan 20 or vision plan on 10.4? Councillor Miller.
Thank you, Mayor. So I've gone through an exhaustive review of the vision plan, and actually I had to take a sober second look because, in fact, the document is quite good. I would certainly recommend some improvements, but actually what I realized is I was looking at rose-colored glasses. It's not that the vision plan is wrong. It's that, with all due respect, we're not implementing or we're not following some of the elements of that vision plan, including transparency and accountability and openness for the public. So there's many pages on there that I would absolutely embrace us to tackle and be measured against performance. But there's still some flaws in it. So we've got to do a better role as council to actually be measurable against what the vision plan is saying. That's what I would have to comment on.
Thank you. Any other questions, comments? I see none. We can read the resolution. We can vote.
Be it resolved that Council of the RM of Springfield approve the vision plan as presented.
Can I get a show of hands? Those in support of vision plan item 10.4 on the agenda? That's Councillors Warren, Fuel, and Therrien. Those opposed? Councillors Miller and Kaczynski. It is so passed. Financial statement, item 10.5, a mover and a seconder, please. Miller and Warren.
Be it resolved that the financial statement for the month of January 2025 be approved as presented.
Any questions, comments from council? I see none. We can do a resolution with regards to that. We can vote.
Just need a vote.
Oh, you already read it. Is that what you're saying?
Yeah.
Can I get a show of hands of those in support? That is unanimous and it's carried. Then we'll go to 10.6. It's a list of accounts. Mover and a seconder, please. Therrien and Miller.
Whereas disbursements have been reviewed for the period of April 16th to May 9th, 2025, be it resolved that all accounts listed on the attached printout from check 162476 to 162611, totaling $1,287,783.40, and EFT number 1 to 27, totaling $256,273.08, be approved for payment, as well as the following withdrawals. Western Financial, $14,909.54, Amelia, $213.57, John Deere, $26,146.86, RBC Visa, $102,356.32, Manitoba Hydro, $35,845.51, Bell Mobility, $25,82.51, Bell Canada, $62.50.44, Volvo, $20,898.78, Red River Co-op, $39,762.18, and be it further resolved that April payroll in the amount of $289,689.82 be approved.
With the resolution being read, any questions from council? Councillor Miller.
Thank you, Bear. I have three just for clarity. And the first one is 162578. It has to do with AMM Trading Company for $422,000. So just what that has to do with or related to?
That's our insurance payment. So Western Financial Insurance.
Okay, but what do you mean? I know it's insurance, but
so our renewal is April 1st. So we get invoice for all of our insurance for buildings, vehicles, our whole certificate of insurance is.
Yeah. And that's what I was looking for, what it was specifically for.
Yeah.
So it's buildings and so forth. Thank you. The next one is EFT Norris Construction equipment for $26,115. Just clarity on what that is.
I will have to get back to you. I apologize.
Okay, and the final one is 162606, Springfield Pride Committee. And again, I'm not necessarily saying pro or con or indifferent, but it's for $5,000. So was that a grant that was provided?
That was a community grant they applied for. Yeah.
Okay. And the reason is I've had some questions from residents on how certain organizations can, I guess, acquire funds for specific events. So basically it's through the community funding, or what's the specific grant?
It's community grant funding. So council passes a set budget for the year and people have to apply and they're approved accordingly.
So I guess the question is, does council have any input on who has allocated these funds? In other words, I know, I think it's Sean or others within the department have some discretion on who they can come to. You know, in a lot of grants, and I've seen because I've been in the province doing grants, sometimes it's first to the kitty gets those grants. So what are the criteria? In other words, I want to make sure that everybody has the opportunity to have a chance at a grant, I guess. And, you know, I'm sure I can look online and there's criteria to that, but is it just the discretion of the internal bureaucracy that levies the grants, or does council have any say on where these, because let's put it this way, I'm not saying this one, but let's just say there's an organization that is a renegade or something inconsistent to the goals of our vision and or even council members. We don't seem to have any input on saying, you know, maybe we should reconsider or not give a certain organization grant funding. I just wonder, again, the transparency and accountability, because we have no discretion. There's a kitty of money, but council has no control on where that kitty goes, right?
Yeah, I don't know how to answer that. No, it's up to staff to approve those applications that come in, and there's questions they have to answer, documents they have to provide. And yes, it's on a first come, first served basis. If they qualify, then they're granted the money.
And that might be okay because political interference is sometimes not very good too, right? So I'm not necessarily opposed to it. I just want to make sure that they're meeting a bar, or any organization is meeting a bar, and that again, because political interference could deny a worthy organization of very important monies for their events and activities. So just I thank you for the clarity on that.
Any other questions from council?
Yeah,
Councillor
can I follow up what Councillor Miller said? How much money we allocated to those grant funds?
I don't have that offhand. I can get that for you. It'd be in the budget under the our community services budget. So we have a grants line. So I can get that information to you.
Okay, thank you. I appreciate that. Another question I have, the check for 162,534.
Derek Reichdale,
Yes.
he's our Part 3 building inspector.
Okay.
Yeah.
Okay, thank you.
Any other questions? Resolution's been read. Can I get a show of hands, those in support? That is unanimous and is carried. If we can go to, where am I at? 10.6?
7.
10.7. June district resolutions there. Has everybody read? I guess we'll read a resolution for that.
Okay, so this is for employment protections for municipal councillors. Therefore, be it resolved that the AMM be requested to lobby the province of Manitoba to enact legislation that enables employees who are elected to municipal council positions to take time off work unpaid to fulfill their official duties without being required to use vacation or bank time, and with protection against any form of workplace retaliation or recourse as a result of their public service. And be it further resolved that such legislation ensure that employees are granted unpaid leave during council meetings, committee work, and other official duties supporting the vital function of municipal governance and encouraging a greater number of qualified and diverse candidates to run for office.
Any questions, comments from council with regards to that? That being read, can I get a show of hands?
Sorry, I missed the mover and seconder on that.
Because we
Sorry.
never got one. Councillor Miller and Warren. And then if we can get a show of hands, those in support of that resolution under 10.7 there, that is unanimous and is carried. The 10.7 is the drainage restrictions to development resolution there. Can I get a mover and a seconder for that, please? Fuel and Warren.
Therefore, be it resolved that AMM lobby the province of Manitoba to only enforce current limitations published in the acts and regulations and remove the internal policy denying water control works licenses on Class 6 and 7 soils. And further, be it resolved that the province of Manitoba engage AMM to participate as stakeholders in the preparations of future internal policies within the drainage and water rights licensing branch to adequately evaluate the impact of these internal policies on growth and future development.
That being read, if there's any questions, Councillor Miller.
Thank you. Just a question to the CEO. Would this be advantageous to Springfield?
We particularly don't find this too much. It seems to be more along waterways, but we're just supporting our neighbor municipalities who are putting this forward.
Good, Councillor Miller. Any other questions from council? Councillor Kaczynski.
And which municipality requesting that?
This came from actually a consulting engineer. He did not provide the list of other municipalities that are supporting this, but I understand it's more like Alexander, those kind of that have more waterways within their municipalities that are seeing the effects of this.
Thank
And if there's no other questions, I see none. If we can get a show of hands, those in support of 10.7 drainage restrictions to the development resolution. That is unanimous. Then we'll get to 10.7. That's the 30-30 initiative there. Can I get a mover and a seconder for that, please? Councillors Fuel and Kaczynski.
Now therefore be it resolved that the AMM be requested to lobby the province of Manitoba to consult with local governments, property owners, and stakeholders prior to moving forward with a 30-by-30 initiative to allow for better understanding of its policies and the platform to address concerns.
That's it? I thought there was more to it. I had a bit of an issue with it there. I think it has a very wide swath that requires more in-depth review. There's no indication of Indigenous consultation, nor is any indication of the Aboriginal reconciliation. And it's a very broad resolution. I find that is just not to my liking there. So, which is, go ahead.
I know that unfortunately you missed the AMM seminar when they talked about this. And so it's actually that the government is doing all consultation with the Indigenous groups and none with private landowners, municipalities, or other groups like the Manitoba Wildlife Federation that are affected by these decisions. So that was the intent of this resolution, is to open it up to ensure everybody is consulted and not restricting.
And that was at the AMM you're saying?
Correct, yeah.
Well, maybe it's just a resolution there, but adding that in there, I totally respect your view with regards to that, but the voting on the resolution is, I find that it's lacking in my opinion. That's just me though. Any other questions or comments from council? Can I get a show of hands, those in support of the 30-30 initiative? That's Councillors Warren, Miller, Kaczynski, and Fuel. Those opposed, and that'll be myself. That is so passed. Deputy Mayor?
Yeah, I'd just like to make a comment. With your concerns, I believe you'll be able to bring those up at the actual district meeting. So they'll maybe make those changes if you feel that that's necessary.
Thank you very much.
You're welcome.
Then if we can go to 10.7, that's the Crown Land public access. Can I get a mover and a seconder for 10.74? Those would be Warren and Therrien.
Therefore, be it resolved that the AMM lobby the province of Manitoba to implement a policy requiring individuals seeking access to Crown leased agricultural lands for recreational or other non-agricultural purposes, including but not limited to hunting, camping, and off-road vehicle use, to obtain prior permission from the leaseholder. This policy would recognize that these lands are designated exclusively for agricultural and would mitigate legal, environmental, and safety risks to both producers and the general public.
With that resolution being read, unless there's any other questions or any questions from council, Councillor Kaczynski.
So how the individual gonna find who is on this land, who is leasing this land? There is access to that information? Municipality have it?
So there are Crown land maps that are accessible, and I believe when they're leased, that information is available to people through the Crown lands office. So I know, like for RM land, when we lease it, we add the person's name in the assessment roll. So if someone comes to see if that's available, it'll show a leasee on there. So I'm not sure with Crown land if that's the case as well. I can confirm, but.
So in the hunting license, do they have specify where it's leased land, or how the individual will know if he can hunt there or not? He just said he just see Crown land and he just goes there, yeah?
Well, you can't really trespass on any land without the owner knowing. So even with Crown land, you should have the permission to be on that land.
Okay, thank you.
Any other questions? Councillor Warren?
And I think Lactabani brought this up based on that there was a hunter out there while the farmer was actually on the land tilling it up, and there was gunshots. So like nobody needs to get shot. while they're trying to till the field.
Seems like common sense, but
Yeah,
I said it seems like common sense, but apparently not.
that's why we need laws. Any other questions from council? We've read the resolution. If I can get a show of hands, those in support of 10.7 Crown Land. That is unanimous and is carried. 10.7, can I get a mover and a seconder for Province of Manitoba Radon Action, Miller and Fuel? Maybe we'll read the resolution and then we can add to it there. Oh, that's a huge one, eh?
Therefore, be it resolved that the AMM lobby the province of Manitoba to develop and implement a comprehensive radon action strategy that includes 9 points that are available to the public online. Further, be it resolved that AMM advocate for interdepartmental collaboration within the provincial government, engaging Manitoba Health, Manitoba Housing, and other relevant agencies, including the Manitoba Lung Association and Cancer Care Manitoba, to coordinate efforts and resources across sectors in addressing radon exposure throughout Manitoba.
Yeah, it's shorter than I thought. Councillor Miller brought this forward from the city of Dauphin, and I'll let Councillor Miller talk to that.
Thank you, Mayor. So in 1992-93, I was the province's radon program coordinator at Manitoba Environment. And so this area is of some expertise I have, and I recommended to the province at that time that they go with mandatory radon screening for all new buildings and so forth. And they were reluctant because, frankly, radon is high in various jurisdictions in Manitoba, including Dauphin and Winkler and Morden, and believe it or not, even in Springfield. So I just want to add to the thrust here. I still believe very strongly radon should be tested in pretty much every home. I don't want it to be a burden to residents, but the tests are fairly inexpensive. And radon is a radioactive gas that causes lung cancer. If you look at lung cancer rates for people who have been exposed to radon, it's very significant. It's not something we should pass off. But I know the government of the day at the time felt that they didn't have the resources and the ability to deal with radon gas. So again, it's a radioactive gas, and their resolution by Dauphin here seems to really fit the bill. I was really excited to see it. As you know, each one of us was contacted by the Canadian Association of Radon Scientists and Technologists, and they're behind it as well. So I don't see there being any negative to this. That's kind of just my point. Thank you.
Thank you. Any other comments, questions from council? I see none. And if we can get a show of hands of those in support of. Do you have some?
Sorry, Christy just messaged me and reminded me, because I did not read out the agenda resolution to add this item. Just following this, I would suggest that council go back and revote on the agenda to include this onto the agenda as an added item. So I apologize for that.
Okay. We get a seconder. Andy? Okay. And a show of hands, those in support of the amendment? Unanimous, it's carried. Then we can go to 10.7. That's already been read, so we'll get a show of hands, those in support of the province of Manitoba radon action strategy. That is unanimous and is carried. 10.8 there, that's the 2025 Eastern District Golf Tournament. Can I get a mover or seconder for that, please? Councillor Warren and Therrien.
Be it resolved that all of council be delegated to attend the Eastern District Golf Tournament held on August 18th in St. Pierre, Jolie.
Councillor Miller.
Thank you, Mayor. I'd make a friendly amendment to that up to 3 individuals participate. And you can be one of them.
Who, me? You haven't seen me golf. Okay. Anybody good with that? Let's see. Everybody is good with that there. With that being read and the amendment shown for 3, can I get a show of hands in support? That is unanimous and is so carried. Nothing for a closed meeting there. If I can get a mover and a second for an adjournment, we can adjourn the meeting there. Warren and Kaczynski. And get a show of hands for adjournment. Unanimous there. We'll adjourn at 8:24 p.m. Thank you very much.